As soon as it receives the ET1 and the ET3, the tribunal sends a copy of them onto ACAS. Let's find out why. Let's see what role ACAS has to play.
Tony, you're a conciliator with ACAS. How would you describe your role in a tribunal case?
Basically, Chris, my role as a conciliator is to try and help the parties reach an amicable agreement, resolve their differences, without the need for a tribunal hearing. ACAS actually has a statutory duty to offer conciliation in most kinds of tribunal cases.
So how would you go about doing that?
Well, once we've got the tribunal case papers from the tribunal office, what I need to do is to contact the parties. I need to do that as quick as possible because the time for conciliation is limited. In many cases, it can be as little as 7 weeks. So that means I'll normally make contact through telephone, but in certain cases we might arrange a meeting, or we might even have both parties together for a meeting.
Well, what would you do if someone was represented by, say, a lawyer or an employment consultant?
The conciliation process doesn't alter at all, but what that would mean is that I would deal directly with the representative, not with their client. I wouldn't speak to their client unless I was specifically asked to. That's important, really, then, that individuals understand, if they've got a representative, that their representative knows what they are looking for from the tribunal process. Because if we did reach an agreement through ACAS, it would be legally binding.
So what do you say to the parties or their representatives when you first make contact?
The first thing I need to ensure is that people understand the role of ACAS and the role of the conciliator. So do people know that ACAS is an independent organisation, we're government funded, and that conciliation is a free process? Then I need to make them aware of the actual role of the conciliator. The most important aspect is that the conciliator is always impartial. It's important that people understand that we actually have no vested interest in the outcome of the tribunal. We can't actually make decisions on their case, and we don't represent them. Other than that, I would make them aware of the fact that the process is confidential. People need to be aware that they can discuss the case freely with us, and that we won't actually pass on any information unless they want us to. The other side of things is that it's voluntary. People need to know that actually, if they don't want to go ahead with conciliation anymore, they don't have to. They can opt out, and they can go ahead to a tribunal hearing.
Well, what sort of things can you tell them?
What we'd be telling them is, well, what does the employment law say in relation to their case? What might be good practice? How does the tribunal process work? What does the tribunal look for in the kind of case that they're actually dealing with? It's providing that information and giving them that kind of information, allowing them to really work out for themselves what the strengths and weaknesses of their case might be.
And once they understand the strengths and weaknesses of their case, what options do they have in the conciliation process?
Once the tribunal complaint has been lodged, there are several options that are open to them. The first would be to settle the claim through ACAS, through conciliation, and around 40% of cases that we handle are settled in that way. Alternatively, they could opt to settle through a compromise agreement. In that situation, the individual would need to be independently legally advised, though. Other alternatives, if the case was an unfair dismissal case, they could opt to go to arbitration, where the case would be heard by an independent arbitrator appointed by ACAS, not by a tribunal hearing. The advantages of that potentially are that it's a private hearing and that it remains confidential. The other options would be the individual withdraws the claim, or alternatively it ends up at a tribunal hearing. Around 25% of all claims that are lodged end up at a tribunal.
So what else can you do as a conciliator?
The first thing to do really is probably listen to people. People are often emotional, or perhaps feel quite sort of strongly about the issues. So listen to them, see what they've got to say about their case and what's happened to them. After that, it's about explaining to people, well, how do we look at the case in relation to the employment law? How do we look at it in relation to good practice and the tribunal process? And what we're really trying to do through that is to minimise those areas where both sides disagree. Try and maximise the areas where there is actually agreement. And that process is what actually leads to a settlement and an agreement.
Well, you've mentioned looking at the case from a legal viewpoint, but conciliators aren't lawyers, are they?
No. Obviously, we're thoroughly trained, and we deal with a lot of cases. We deal with over 300 cases a year, so we build up experience very quickly. Obviously, it's important that we also make clear to people what we can't do. We can't advise them about their case because we have to be impartial. Therefore, I couldn't advise somebody whether or not I thought they'd got a strong case or a weak case. I couldn't help them prepare their case, and I couldn't advise them what to offer or what to accept if an offer was made.
Yes, you're not going to take sides in any way, are you?
No, as I said before, we don't have any vested interest in the outcome of the case, and we have to remain impartial.
What happens if the parties do manage to reach an agreement through ACAS?
The first thing I have to do is to ascertain to my own satisfaction that we have actually reached an agreement. What I mean is that I have to be 100% clear that both sides are happy with the agreement and that they fully understand what the agreement entails. Once I'm happy with that, I can notify the tribunal of the fact that we've reached an agreement. We can have a legally binding agreement actually verbally before anything is actually signed in writing. And once I've notified the tribunal, they will take the case out of the list of hearings. What I would then need to do will be to actually put that agreement into writing. It would go onto a form known as a COT3, an ACAS form. That would be signed by both parties. Both parties would keep a copy, as would ACAS.
And what would a typical agreement contain?
Typically, the most common type of agreement would be to settle the case, to settle all claims in return for a sum of money. One of the advantages of conciliation, perhaps in comparison to the tribunal process, is that typically the tribunal can only award a sum of money, when often what the individual might be looking for might be other things. Through conciliation, we can actually put anything into an agreement, provided it's legal and provided both sides agree. So the individual might be looking for perhaps an apology, perhaps a reference, perhaps they're looking for a reassurance that the kind of treatment that they actually suffered won't happen again. From the employer's point of view, they might be looking for a confidentiality clause. All of those sort of things can actually be incorporated into an agreement.
Whereas a tribunal can't order them?
No.
So why should people use conciliation?
From an individual's point of view, or from the employer's point of view, they've got nothing to lose by using conciliation. We've seen it's a voluntary process. It also provides a way of exploring settlement, exploring the situation in perhaps a more informal environment, perhaps a safer environment. They also retain control. We actually reach a lot of agreements because it's the parties' agreement. It's not an ACAS agreement. It's for the parties to come to an agreement and it remains in their control, unlike the tribunal, where obviously, ultimately, the tribunal makes its decision and issues its judgment.
It must be much less stressful.
It's much less stressful for people. It can be less expensive, can be less time-consuming. And I think the stress side of things perhaps shouldn't be underestimated, because the tribunal process of its very nature is adversarial, and as I said before, it is a less formal approach through ACAS, and through conciliation people will often perhaps take things from a neutral third party that they might not from the other side.
There's a lot to be said for it being private and not on the public record, isn't there?
There are certainly advantages to conciliation, and that might be a prime reason why somebody would look to try and reach a settlement, because obviously the tribunal hearing is public and there could be the risk of adverse publicity.
And what does the tribunal do whilst conciliation is going on?
The employment tribunals can do every aspect of managing the case apart from actually listing the case for hearing. So unless the employment tribunal tells you otherwise, you need to carry on preparing your case. Because ultimately, Chris, if conciliation isn't successful, then the case will be heard at a tribunal hearing.
Finally, Tony, and in the round, what is your advice to people thinking of using conciliation?
Why not try it? We said they've nothing to lose by using conciliation. They might reach an agreement that they'll be happy with. If not, they've got the right to go to the tribunal and for the tribunal to actually determine their case. At the end of the day, it can be less expensive, it can be less time-consuming, it can be less stressful, and any agreement they reach will be their agreement.